You were told kaende means development and other nice things. I invite any of you because it's an open country. Kaende is not an English word, it's not a Swahili word, it's not a native word from any of our native languages. It is Sheng, street slang in Nairobi. And I told you yesterday, all you need is pick your phone, call a young person, ask them what is the meaning of kaende. And I told you the meaning is, I don't care. Na liwe liwalo. Kusera. And I recall telling you, because it is in the nature of KAWIRA to do these type of things. When I mean it is in her nature, I mean she can't help it. It's part of our chemistry. Unfortunately, we have human beings like those, and they are our beloved brothers and sisters. We can't get rid of them, but we can't allow them to be governor. We can't allow them. They are our beloved mothers, sisters and brothers. But the very reason chapter 6 of our constitution and all these laws we've cited is an acknowledgement that not all of us can be a state officer. Some of us may be very intelligent. They may be very eloquent. They may have very good mobilization skills. As a matter of fact, they may be loved by the people. Barabbas was so loved that the people chose him over the Son of God. But it doesn't mean they are the right holders of certain offices. And if, by what I called in the last impeachment, that seemed to bring me into trouble with the Senate, an aberration of democracy. Mr. Speaker, Article 181 exists because the drafters of our Constitution, in their wisdom, realized democracy can produce aberrations, counterintuitive products. And governors like the one before you, I very humbly submit, Mr. Speaker, they are an aberration. They are not the type of product our democratic system of government was designed. And because the makers of our Constitution knew this sort of problem can arise from time to time, this august Senate and the County Assembly were given a counter-majoritarian power to remove state officers for violations such as those before you. I told you about Shaggy yesterday, and his song, It Wasn't Me. And true to my prediction, even though there are no prophets in my clan, the governor came here, and the common denominator was that it wasn't me. I haven't done a single thing. Luckily, Mr. Speaker, today, while cross-examining our own legal man, Dixon Monenen Kanata, we were able to show the Senate, not my words, but Section 30 of the County Governments Act, and we were able to demonstrate to you it is immaterial that the acts in question were not personally committed by the governor, because that section says the governor is responsible for those acts. Those are not my words. The section we read says the governor shall be accountable. Those are not my words. The word used in the statute is the governor shall be accountable. In fact, and why this defense cannot end, Mr. Speaker, is you would be setting a very dangerous precedent. In fact, you will have guillotined and killed. Chapter 6 and Article 181, because anyone who walks in our villages, in our streets of our cities, you don't need to be very knowledgeable to know senior state officers invariably act by instructing someone else. You rarely ever find a governor, a president, or whoever directly doing something personally. Yet our constitution says they are accountable to Parliament in the case of the national government. They are accountable to the county assembly. Those are the words of the law. Mr. Speaker, if you are to uphold this defense, it would mean no one would ever be impeached, because all you need to do is act through others. Luckily, Mr. Speaker, we also cited another law for you that expressly speaks to acting through others. And in short, all we are trying to tell you, Mr. Speaker, is that there is no valid defense to the charges against Governor KAWIRA MWANGAZA. What she has done, which is what she has done all along, is to tell you, it wasn't me. Even if she was caught on camera, it wasn't me. Even if she was caught in various places, in Shaggy's song, the man engaging in hanky-panky is caught in the bathroom, on the sofa, and in yet another place, and it's all recorded, and his persistent reply is, it wasn't me. We have shown you that defense is not available as a matter of plain law, but it is not also available as a matter of principle. I propose to leave it at that point, Mr. Speaker, to share the remaining minutes with my learned colleague, Mr. Muvengai Jacob Ngwele, who will take you to the specifics of what is the case we brought before you, what is the response to that case, what are the admissions the governor made at the county assembly, and when all that is done, we shall beseech you in the name of God, whether it is the Christian God or the God of the Nyambene and Mount Kenya hills that they are MERU worship before the current civilization, that the time to stop this madness in MERU has come. And if there is no reason, if we haven't proved or satisfied you, the governor is the bishop in the Holy Book. In the event we have not persuaded you on the evidence, Mr. Speaker, I hope we have persuaded, wherever the truth lies, there is an unsustainable crisis in MERU. And even if you must jettison one person to save the ship, called MERU County with the 1 million inhabitants, your act is still justifiable even under the Holy Book. I now cede the floor to Mr. Jacob Ngwele.
Just to remind you, Council, your time terminates at exactly 8:50.
Thank you very much, Honorable Speaker. My name is Jacob Ngwele. I'm an advocate of the High Court. I've been given this onerous responsibility of taking the House through the evidence which has been submitted before the August House. Mr. Speaker, the Senate is sitting here pursuant to Article 181 of the Constitution, which provides for removal of a governor from office. The question which arises and which begs this House to look at, what is the standard which this House should apply on the evidence which has been submitted by the County Assembly of Meru. My learned colleague, my learned senior, Elisha Goya, when we started, he did inform the Senate that this House is sitting in quasi-judicial proceedings. I beg to differ. The test applicable when you're evaluating the evidence which has been submitted here has already been established by the Supreme Court in 2 cases. That is, the first one is the case of Wabora, and the other one is Mike Movie case, whereby the court was clear that impeachments are a tool of political accountability. Impeachments are not criminal, neither are they civil proceedings. And therefore, the standard, the applicable standard before this House has already been established that the burden of proof, the standard of proof, is slightly above that for civil cases. That is on a balance of probability and below the beyond reasonable doubt. So this House is not evaluating the governor's criminal culpability, but it is subjecting the governor to political accountability. Political accountability for the actions of the office which she occupies and the deeds which she has undertaken throughout that period of time. It is our submission that the County Assembly of Meru has demonstrated and proved its case in accordance with the standards and tests which are laid out by the Supreme Court in the decision. And I'll proceed to take this House through the specific violations which have been submitted. Mr. Speaker, the charge sheet before you has got 7 counts. And out of the 7 counts, those 7 counts consist 39 specific violations. And the first count, which of course is going to be read later on, is misappropriation and misuse of county resources. Article, I can't read the time.
You have 30 minutes.
Good, thank you. Article 181 of the Constitution provides the grounds which the governor can be impeached on. That is gross violation of the Constitution, gross violation of the laws, that is conviction, criminal conviction on breach of the national law. We do submit that on count number 1, that is misappropriation and misuse of county resources, this charge has been substantiated and proved. And I'll proceed to explain to this House or demonstrate to this House how this charge has been substantiated. When you look at the charges, we have drafted them that the governor has engaged or by connivance or complicity. So the governor is implicated either directly or indirectly. What my learned colleague, Mr. Mudomi, has said, that it's not about the governor's direct action, so that if the Senate finds there's no direct or individual responsibility on the part of the governor, then the governor is going to be acquitted. No. There are instances when the governor is complicit or connivance or part of that violation, and that is what we're going to prove. This charge, the first one, is about embezzlement of county funds and withdrawal of county funds. A lot of energy has been dispensed here to demonstrating how a total of 78 million was, I can use the word, looted, swindled, plundered, or carted away from the Meru County Treasury. And this swindling involved a scheme which comprised a clique of 2 groups. One was a clique made up of governors' relatives. And all of you have heard names: Miriam, Rose, Kenneth, the Guatai, and also Meme. This was a clique, an inner circle clique of the governor, which was used to pilferage money from the county treasury in the name of interest or prepayments. The other clique was a group of officers working under the office of the chief of staff. Collectively, this group of people swindled an amount of 78 million shillings over a period of 1 financial year. The IFMIS data, which has been produced, if you do a total computation, and this amount of money has not been disputed, none of the witness from the governor's side has disputed the totality of this amount. What they have done is that they have only submitted evidence to justify an amount or to account for an amount of 2 million only. What they have not done, they have not brought evidence to justify the balance of the 70 million. This group, the first clique, was responsible for 6.5 million shillings. The other group, that is the chief of staff and his officers, they were responsible for the balance of the amount. And in that group, you'll find a person, I'll just single out the individual, by the name Kadhure Rukaria. Individually, over a period of 1 year, she was paid in form of prepayments an amount of 21.8 million shillings. We have sat here for 2 days. No document is in front of you justifying that payment. Nobody has disputed whether this payment was withdrawn from the county treasury. Nobody. No documents in form of a payment voucher, an impressed warrant, has been submitted to justify. There has been a deliberate attempt to distort the story and to focus the attention of the Senate to the impressed. And the narrative is this amount of money was being paid as a form of facilitative interest for the governor's entourage. Can a governor's entourage collect a totality of 78 million? The amount of money which has been accounted for is only 2 million shillings. Where are the documents? Where are the vouchers? And when we asked, when the assembly requested for the documents through their summoning powers, they were told that the documents are with the Auditor General. And in the letter which is in the document, which is in the bundle of document, indicates that the documents are being used for preparation of financial statements. Everybody who has got elementary accounting knows very well that you don't generate financial statement using vouchers. Financial statements are generated using cash books and ledgers. And even if these documents were taken to the Auditor General, where is the delivery book? No evidence has been submitted to show where that amount of money to support that expenditure. And in absence of such document to controvert this allegation, we do most humbly submit that this allegation of embezzlement of funds has been proved. On their defense, what they attempted to do, they submitted documents here, a bundle of documents, which we have raised issues about its authenticity. We do submit that these documents were afterthought. They were generated ex post. They were ex post creations to justify those two, and they were not, in the attempt to justify, they only justified 2 million shillings. When they had an onerous obligation of justifying 78 million. Those documents were not signed, they were not examined, they did not comply to elementary accounting standards applicable to any accounts department in a public institution. So we do ask the Senate to disregard that defense which has been put forward and know that 70 million shillings, as we sit here today, has not been accounted. They had the obligation, they had the responsibility of calling in the Chief Officer Finance. They had the obligation, they had the opportunity to call in the CC Finance. They had at their disposal the entire county treasury to come and explain those amounts of money. They have not, and for that reason, we do submit that this allegation, that is count 1, has been proved. I'll swiftly move